The spark was a baby born in Bloomington, Indiana in 1982. Baby Doe was born with Down syndrome and a detached esophagus, esophageal atresia. This meant the baby couldn't eat. The esophageal blockage was surgically correctable with a high success rate. However, the parents, consulting with their obstetrician, decided to refuse the surgery. They cited the potential low quality of life due to Down syndrome. They essentially argued that it was better for the child to die than to live with severe intellectual disability. The hospital sued to force treatment. The courts debated the issue for 6 days. While the lawyers argued, Baby Doe sat in a corner of the nursery. He was given pain medication, but no food or water. He starved to death after 6 days. When the news broke, the public was horrified. Disability rights advocates argued this was eugenics, plain and simple. They pointed out that if a normal baby had a detached esophagus, the surgery would have been mandatory. The decision to withhold care was based entirely on the presence of Down syndrome. They argued that the parents and doctors had conspired to discriminate against a handicapped citizen, denying him his right to life. President Reagan ordered the Department of Health and Human Services to intervene. They invoked Section 504 of the Rehabilitation Act of 1973, which forbids discrimination based on handicap in any institution receiving federal funds, like hospitals. They posted signs in NICUs across the country with a 24-hour hotline. Discriminatory failure to feed and care for handicapped infants in this facility is prohibited by federal law. They created Baby Doe squads, federal investigators who would rush to hospitals to inspect medical charts if an anonymous tip came in. It was a massive projection of federal police power into the nursery. The Supreme Court eventually struck down the specific regulations regarding the hotlines as government overreach. However, Congress immediately passed the Child Abuse Amendments of 1984. This law codified the core principle: withholding medically indicated treatment from a disabled infant constitutes child abuse and neglect. States were required to enforce this or lose federal funding. The law effectively removed the parent's right to decide on non-treatment based on quality of life judgments. If the treatment works medically, you must provide it. The law carved out 3 specific safe harbors where treatment is not required. First, if the infant is irreversibly comatose. Second, if the treatment would merely prolong the act of dying, essentially, if death is inevitable regardless of the intervention. And third, if the treatment is futile and inhumane, meaning the treatment itself causes pain without offering a hope of survival. Notice what is missing. Quality of life is not an exception. You cannot say, this child will be blind and deaf, so we shouldn't treat. Under the Baby Doe rules, that reasoning is illegal. 10 years later, the pendulum swung the other way with Baby K. Baby K was born with anencephaly, missing most of her brain, possessing only a brainstem. Most anencephalic babies die in days. The standard of care is comfort measures only, but Baby K's mother insisted on keeping her alive with a ventilator whenever she had trouble breathing. The hospital argued this was medically futile. It served no therapeutic purpose because the brain would never grow. They wanted to stop. The mother sued. The court ruled against the hospital. They didn't cite the Baby Doe rules, they cited EMTALA, the Emergency Medical Treatment and Labor Act. EMTALA requires ERs to stabilize anyone with an emergency medical condition. The court ruled that when Baby K came in gasping for air, that was an emergency. The hospital had a duty to stabilize her breathing with a ventilator. The fact that she was anencephalic was irrelevant to the EMTALA duty. This created a paradox where doctors were legally forced to provide care they deemed ethically inappropriate and futile. It showed that patient demands can weaponize consumer protection laws like EMTALA to force treatment. These cases highlight the problem of futility. Quantitative futility is when a treatment physically won't work, like CPR on a decomposed body. Qualitative futility is when the treatment works. It pumps blood, but the outcome is not worth achieving, life in a permanent coma. Baby K was qualitative futility. The ventilator worked, but the doctors felt the life it sustained was not a benefit. The mother disagreed. In a pluralistic society, who gets to define worth it? Some states, like Texas, have passed laws giving hospitals a safe harbor to stop futile treatment after a review process. But generally, the law defaults to preserving life. Today, neonatologists try to avoid the courts at all costs. They practice shared decision-making. In the gray zone of viability, like a baby born at 22 or 23 weeks, doctors will generally defer to the parents' wishes on whether to resuscitate. But for clear-cut cases like Baby Doe, Down syndrome, the law is clear. You treat. The legacy of Baby Doe is that disability is no longer a valid reason to withhold medical care in the nursery. To conclude, Lesson 3, we have seen how the federal government stepped into the nursery to protect vulnerable infants from the judgments of parents and doctors. We have seen how laws like EMTALA can create strange ethical obligations. The central theme is that in pediatrics, the best interest of the child is a matter of public law, not just private opinion. In the next lesson, we will pivot to another legal constraint, the duty to keep secrets and the duty to reveal them. We will discuss confidentiality and the Tarasov case.